abusia yin cha onemo akwa abasron kosomre channel so hada so e be media GH abusia for eyade a former attorney general Godfred Dame abusia amaneboni echemu echese papai akopiemu ewo CID Headquarters. Obi bisa say die na si die na ba no ntia ma papai akopiemu ewo CID Headquarters anase beka say CID atonsa e de afra papai. Eyade a Richard Jakpa release some issues bi na so some statement bi e fa papai. One person kasa ba wa no. Pese ye ko na ekokotie ensemo a Richard Jakpa e de ba abontie no nti ama CID atumi atonsa e de afre Godfred Dame a oye former attorney general. Abusia ha e da so e be media GH. Se ena de connect channel so a ene de kwan se be so ba je ma hwe video si ya bo made awa subscribe like no abo sha for person bi atie no anya bi atie abusia yenko ne gogotie ensemo a asi ewo CID Headquarters anina efa Godfred Dame ho emra sesia yedanse.
A fresh one that has come is that the CID has invited Dame, as in Godfred Dame, to come on some issues that Jakpa had raised with the CID. But I want to ask first off, if issues of this nature is settled in court, can someone also raise the same issue again in connection with the same issue that has been dealt with by the court to CID to say we should now come back again, look at some of the things that really went wrong? Is it proper?
Absolutely, yes, because what might have been dealt with in court is legal. Again, you know, what the complaint against the former Attorney General is in two folds.
Okay.
We also have the ethical part of it.
Okay.
You know, even somebody can even also go to General Legal Counsel for him to be interrogated, because it is ethically wrong by our profession for you as an opposing or a counsel on the other side to interfere with a witness. So, even as the matter might have been dealt with in court, ethically some people can also raise issues. And so, for me, I don't think the matter is done with. A lot, if it can be established that indeed he has an interaction with the witness of the accused person in a manner that sought to say that he is trying to coerce or teach, coach, show the person how he should conduct himself in court, that tells you that then it means that the judiciary, or what we ought to have as justice in the court of competent jurisdiction, is not seen. Because everybody goes to court to get justice. And justice must emanate from free and fair processes. Where there is duress or undue influence of a sort, for which reason a judgment is given, then that is not fair and that cannot be justice. And so mind you, he was the head of all lawyers in this country, and he was the legal advisor to the government at the time. So if it could be established that indeed he had such an interaction, that would be a doom day again for the profession we all cherish, because then I don't know what kind of example the leader sought to give to the people of this country.
And now he's telling all of us, I mean, in a 50-page response that, I mean, listen, there's no any piece of evidence, I mean, adduced in the matter, either by prosecution or defense, I mean, which is alleged to be fabricated by him. I mean, in terms of what Richard Jakpa is saying. I mean, so what should Richard be doing? Now, Richard has to prove beyond doubt that there is enough evidence to prove that Dame did what he's accusing him of?
Of course, yes. The law is explicit that he who alleges must establish or must prove. Who he avers, make an averment. It is not enough to make an averment in the vacuum, but an averment must be followed by evidence, and that is provided for by the Evidence Act. there is an obligation on any party who goes to court to bring sufficient evidence that is capable of swearing or capable of convincing the court that actually whatever averment you have made is true. Otherwise, you stand the chance to fail in your averment that you might have brought before the court. So under these circumstances, now the obligation, the duty is now imposed upon Richard Jakpa to bring evidence sufficient enough in order to show to court that actually he has done it. And once that is established, then there's nothing again. But otherwise, the law is there to protect both accused and also the complainant. And so that is why there is a high burden of proof that is placed on anyone who actually makes such an allegation. So now, where we stand now, it is over to Richard Jakpa to bring sufficient evidence to court or to the investigative body to show that actually Godfred Dame has actually done what he is alleging that he has done.
Because I'm not a lawyer. I'm not into the space, but looking at the way things are going, I mean, for Jakpa to say that he has enough to tell, I mean, that Dame seriously attempted to persuade him to testify. Yeah. I mean, in particular manner, so as to dishonestly and then wickedly and without an iota of conscience implicate Dr. Atto Forsen. I mean, you're a lawyer. Such matters, I mean, such areas of this, is it going to be very easy to prove this case?
He is saying such a thing has happened. And you see, as a lawyer, the first thing that comes to my mind is why, in the first place, a counsel on the opposite side should meet a witness in a matter that is involved.
Okay.
Right?
Okay.
That is very pertinent because it is not allowed.
Okay.
And in any case where you choose to meet a witness of the opposite side, you need to let the defense counsel to be aware. You need to let him also know that I am going. And sometimes it is even more important that you even meet that witness with the other lawyer. So that if there are certain things that you need to sort, it will be sorted with his lawyer. But to the extent of meeting, not to prejudice the matter before the investigative body, but as a lawyer, things are running in my mind. Why, in the first place, should he even contact the witness of the other party? Why?
Okay.
So, if there is anything at all to go by, that is where we should start it from. Now, why should he meet that witness? And if that why is answered, then we try to see whether or not it is justifiable under the circumstance to have met him. If not, then he should be found wanting.
Like your views on this, between petitioning the CID and petitioning maybe the bar, which one would have been much perfect to deal with this issue?
Well, for me, if it comes to the practice of the law, you will appreciate that things of this matter, it is within the ambit of the General Legal Counsel, where a lawyer misbehave or misconduct himself. General Legal Counsel is where you take him or her to, so that they will be able to sanction him accordingly. So sanctions such as even taking or revoking of license could be done for the person, right? So, well, again, I don't know if there is more to it because I've not had the benefit of reading the petition, for which reason Richard Jakpa could also go to CID. But otherwise, for me as a lawyer, I know that where there is a misconduct on part of a lawyer, the best place to go is General Legal Counsel, because they actually regulate the practice of law in this country.
Lawyer, after going to court ended the case. We are back again to petition the CID. And then we are even looking at the General Legal Council being petitioned, or the conduct or the ethics and all that, the ethical, practices and all. If somebody says that Jakpa or Richard Jakpa is bathing in the soup or the river of witch hunting, would you agree to that?
Normally, until a matter is even finished before the court, or until something happened, you cannot just go to General Legal Council. You can petition them.
Okay.
So it is after the process that, and even at the time, I think Richard Jakpa was also before the court. So he was also trying, maybe, I am not speaking for him, I'm not his lawyer, but I think at the time he may be fighting for himself. Now that everything is dash and done, I think this is the time for him to also fight his cause.
So you wouldn't see
so
it
we
as
cannot label
hunting,
this
right?
as witch hunting. This cannot be as witch hunting.
Okay.
Maybe in his opinion, he's trying to make sure that due processes are done and that a lawyer should not misconduct himself in any way, like he's alleging that Godfred Dame has done. Yeah.
Very well. Before you take leave of us, I mean, the issue of the Ashanti Regional Chairman of the New Patriotic Party, i.e. Bernard Nchubuesiakon, won to me, Chairman, 1 million bail pending the commencement of trial today. I'm sure you've heard it.
Yeah, I did hear that.
What's your view on that?
Oh, the grant of bail is actually discretionary.
Okay.
And anytime either investigative body or a court is granting bail, depending on the gravity of the accusation, they will actually seek for surety. And it is for the purposes of the fact that they want to, at all times, get him whenever they need him to appear before the investigative body or court. So for the bail conditions, it is by law that if the person has done something that is so grave, then you have to assure yourself that you tie him to something that will make him come back for the investigation to be continued. So under the circumstance, it is just fair to say that yes, it should bring some surety. As to whether that is exorbitant or not, like I said earlier on, it is at the discretion of the body. But in any way, the law also provides that if it is too exorbitant, you can at any point in time apply for variation of the bail condition. But I think he has met it. I don't know.
Yeah, he did. He
has
did.
met
I
that.
mean,
So
he met it, yeah.
I think there is no dispute about that. So he will come and then stand trial.
Okay.
And we see what the court will tell us at the end of the day.
Very well. Lawyer, thank you so much for talking to us.
Kojo, it is always a pleasure.
Thank you.
Talking
Thank
to
you. And Mijidi is enche. We no interview no yebe ni chimu.
Papa, me go so see a chin
Lawyer, thank you so much. Lawyer Raymond Bedema, and you know AD and common law lecturer, and you know AD and common FA. Two major issues that is really happening. One has to do with Richard Jakpa and I face so a former Attorney General, Ora Odame, Omo Instance Seminar Koso. A court CID and afre ASR case in a home come and ED and over to me the wo messages aba and I face no wo text messages in a WhatsApp messages in American kind in amount a fear hanum 56 minutes past the hour of 8 a.m. A hanum a Kesben 92.9 now face no a Kesben TV and then on Facebook a Kesben 92.9 Kesben 92.9. I'm a Samsung for Kojo Prekodankwa and meti ejuma mede eye jumede we ebro ma menken kan eye messages ni binafi member back ni enko eye ahoma no so biwa na me kan we afie kwablanfi of Pokwase Benghazi you're saying President John Mahama's 9 months in office is better than former MPP government because he has achieved a lot. Stable power that has no more doomsort. All bad roads are under construction. Cheap food commodity, reduction in corruption, stable lorry fare, free bet tax, stable cement price, standardize free SHS, etc. We believe in President John Mahama that he would do greater things for Ghana. Greetings to Honorable George Opare and Honorable Agbo Akwete, MCE for Ghana North Municipal Assembly. We efi kwa Blanvi of Pokwasi Benghazi and Ode Nedie Ebaye. This one also is coming from Afrani Electricals, Pakosu Estate, Kumase, or say, the Galamsey getting out of hand as a result of unpatriotism on the part of both politicians and we, the ordinary Ghanaian, especially politicians, because they promise to create jobs but end up enriching themselves whenever they get power without thinking about those who voted. Hence, the sense of unpatriotism by the Galamseyers to destroy water bodies and land. I not say. So the only solution to Galamsey Kanka is to provide more alternative jobs for the Galamseyers and for those in power to stop looting and milking the nation when they have power. And then I have this one from OPK who says that MPP is right in not honoring the invitation of PRC to increase prices of utilities because the incompetent, hopeless, and insensitive government, Mahama and the NDC have overburdened Ghanaians with too much taxes, bringing hardship on Ghanaians. So MPP will not be part of this wickedness, and NDC gurus are doing Galamsey with impunity, destroying our lands, water bodies, and our food crops. So Ghanaians should rise up against this oppressor's rule because this is not the reset they promised. Or the Eba, and then this one says what for. I want me to be invited, and the likes of Kwekubuahin working freely is a pure political, but Ghanaian pure political. But Ghanaians shall be the best judge come 2028 general elections. We all know that how President Akufo-Addo even put his presidency on the line, and we all know how MPP lost all the Galamsey areas. So if our lands and river bodies have been designed by the Galamsey menace, then we can say that President Mahama have failed in fighting against Galamsey. Yaw Osanki de from Taifa and Ode Nedie Ebayeno. Mamu di anaba ni nyina no making kind ni nyina amamu. But indeed, enra minority caucus a press conference Edin Sembi Etuja telling all of us say their course war with the CEOs when it comes to President Mahama no enya dia ekoyi enya dia sebio omofo say papa and omo press statement this is what they said. President Mahama's CSO's meeting encounter a publicity gimmick to cover up his failed fight against Galamsey. That is what the minority caucus eka. Na utie kakra or say. The minority caucus in parliament has keenly followed a recent development relating illegal mining and its impact on our water bodies, forests, and health and livelihoods of our people. The caucus has also monitored the president's encounter with selected civil society organizations on the illegal mining menace in the government and the government response at the encounter, which seeks to downplay the agency to deal with this looming national disaster. It is clear that the encounter with CSOs was a publicity stunt calculated to cover up the government's failed attempt at dealing with the mining. It is obvious that the Galamsey menace keeps worsening by day. We are therefore surprised that amid increasing turbidity levels of the glaring browning of our water bodies, the heavy contamination of soil and food crops, as recently confirmed by the joint report by Pure Earth Environmental Protection Authority, the wanton destruction of our forest resources and the indiscriminate degradation of our lands, the President of the Republic could look into the eyes of Ghanaians and tell us he is winning the fight against illegal mining. Instead of dealing decisively with the looming crisis, as promised when in opposition, the government has resorted to publicity gimmicks to sway the minds of unsuspected Ghanaians from its failures. Without a doubt, this government lacks the political will to fight Galamsey and has merely resulted in renaming of policies and programs introduced by Akufo-Addo's government. It will recall that when the Akufo-Addo government came into office in 2017, the Galamsey menace had reached a crescendo, and there were warnings that Ghanaians would have to import water if the destruction continued. The deal with this government government put a 6-month moratorium on all forms of small-scale mining that is legal and illegal, which was extended for a period of 1.5 years. During this period, under the outstanding leadership of President Akufo-Addo's government. 1. Establish the Ministerial Committee on Illegal Mining to coordinate